This is the time set for a status conference in the matter of iCap Enterprises, Inc., case number 23-01243. On the line, on behalf of the debtors, we have Julian Garuli.
Good afternoon, Your Honor.
Patrick Jones.
Good afternoon, Your Honor.
And Madhu Pocha.
Good afternoon, Your Honor.
On behalf of the Official Committee of Unsecured Creditors, we have Jay Cornfield.
Good afternoon, Your Honor.
John Bender.
Good afternoon, Your Honor.
And Jason Wax.
Good afternoon, Your Honor.
Assistant U.S. Trustee Gary Dyer.
Good afternoon, Your Honor.
Darren Cratley on behalf of Redmond Funding Group.
Good afternoon, Your Honor.
Matthew Lesnick on behalf of Christopher Christensen.
Good afternoon, Your Honor.
Brian Free on behalf of Jim Christensen.
Good afternoon, Your Honor.
On behalf of Umpqua Bank, we have Jason Ayers.
Good afternoon, Your Honor.
And Tara Schleicher. Good afternoon, Your Honor. And on behalf of Subcontra REIT, We Alliance Secured Income Fund, and Jason Yellowitz, we have Garrett Ledgerwood.
Good afternoon, Your Honor.
And David New.
Good afternoon, Your Honor.
Is there anyone else on this line that I did not identify? This hearing is being...
here on behalf of Lima One.
Thank you. This hearing is being recorded. Please proceed.
Good afternoon, everyone. I hope you're all doing well. So we're here today for a status conference. There's a lot of balls in the air right now. We have 7 filed objections to the debtor's motion to approve the DIP litigation finance funding, largely based around the Ponzi scheme. I've reviewed all of those. I don't think, and I'm not prepared to decide everything substantively today, but it's going to be interrelated with the scheduling and process, which is part of what we're going to talk about. I also want to talk about process on the cooperation agreement. We have this Buckhalter issue, and then I don't know if Bruce Medeiros joined. I know that he represents United Rentals, which has a pending contested motion for relief from stay that they were asking for a hearing date, and I thought maybe we can check that off today too, if he's on, given that we're talking about scheduling more broadly. So, as I said, I've read the papers and I read the debtors, the committees. Bush Cornfeld filed as a courtesy to Joe Melvany emergency motion with the proposed expedited schedule, which we can talk about. I thought it made sense to kind of step back and deal with some of this in chunks. So chunk 1, which I'm not sure has a contested evidentiary aspect, and I'm not sure even needs to get pushed into April, is the debtor's request to approve the cooperation agreement. And the cooperation agreement is expressed on, this is cooperation agreement at page 5, that is a sentence reading, quote, "For clarity, this agreement is not conditioned on the entry of the Ponzi scheme findings and conclusions, nor the DIP litigation financing." And I believe the only party out of the 7 who filed objections that really objects to anything relating to the cooperation agreement is Umpqua Bank. So my thought is perhaps we can just deal with that next week and not defer that to April. Obviously, Umpqua raises, I think, a very serious issue relating to the Buckhalter firm that I guess doesn't have an unrelated matters waiver here. So there's a conflict issue, and there's also a disclosure issue. When I was in practice, one of my former law partners used to reference the famous John Jolene case and say that Rule 2014 is the only thing that can send a business bankruptcy lawyer to jail. So I assume that's going to get fixed promptly by the Buckhalter firm, and Mr. Dyer may want to be speaking with them about how that disclosure was overlooked. So there's both a disclosure issue and a conflict issue. I haven't fully thought through, Mr. Gooley, about whether that affects you and whether that travels with you to O'Melveny. I don't know if any of the parties are going to raise that issue. I don't know how much more we should talk about this today, but it did seem to me that obviously the disclosure and conflicts issues are incredibly important. This needs to get rectified. But I think this is the only issue anyone raised with the cooperation agreement. Obviously, it kind of is out of left field. So absent that, I've reviewed the cooperation agreement. I understand what the committee and the debtors are doing. All of it makes sense and seems efficient. And again, no one else is objecting. But Umpqua Bank did raise what, I assume motivated the courtesy filing last night by the Bush-Kornfeld firm. So, Mr. Gooley, what do you think about breaking the cooperation agreement off? And I guess how do we get these Buckhalter-related issues cleaned up?
Thank you, Your Honor. For the record, Julian Gooley for the debtors. Your Honor, in sort of initial strokes, I think you're thinking what the debtors are, which is their issues raised in Umpqua's objection to the 9019 motion. I think, as the court described, the things that will have to be addressed. And I know we'll, speaking for the debtors, and we'll be moving quickly on that. I think, Your Honor, on the substance of the 9019, I know we've discussed this with counsel for the committee, and would absolutely be interested in Your Honor's additional thoughts and discussions with counsel for Umpqua Bank. But I do think that it makes sense to hold March 27th for the settlement agreement hearing. I would say, Your Honor, that our hope would be to engage, hopefully consensually, with Umpqua around what that settlement sort of, if we can get there, what a settlement approval order looks like. It seems to me that on the merits of the debtor settlement with the committee, allocation of sort of work streams, cooperation, and the like, I don't think Umpqua articulated an objection on to those grounds. And I don't think, Your Honor indicated, that there's an evidentiary issue in dispute for the 9019 motion. So I think we would suggest holding that date at 3/27. I think, Your Honor, this may be a little bit for later in the hearing, but I think it's now for a in-person hearing on the 27th. If we're not going to do anything other than the settlement agreement on the 27th, I think it probably could be by now, but that might be farther down the road.
Okay. Thank you, Mr. Whelan. I did note, obviously the conflicts issues have some wrinkles. I did note that the cooperation agreement, and this is at page 3 of the agreement, in the bottom third of the page, has a paragraph specifically referencing the Umpqua claims that does state that the parties have agreed that if those claims are actively litigated, John Bender / Cor Cronin will be serving as sole litigation counsel. Again, that may not be a perfect answer to the conflict issue, and obviously I'm not deciding that today, and if there are issues with anyone's fees or disclosures, those are all down the road. But I did note that the agreement itself wasn't contemplating that Buckhalter would be involved in any affirmative litigation against Umpqua, at least as far as I read it. But I guess, Mr. Ayers and Ms. Schleicher, if you'd like to comment just about the cooperation agreement issue. Again, Umpqua is the only party objecting, but I think it was an objection that makes complete sense to me, having read it. So,
yeah, thank you, Your Honor. This is Jason Ayers for Umpqua Bank. We obviously do have a lot of issues here, and we need to understand Buckhalter's position. To be blunt, we haven't heard anything from Buckhalter since I received a communication last week from their ethics counsel, stating that Buckhalter would, in his words, cease participating in pursuing Ponzi findings and related issues. I think the issue people are overlooking, what's happened here is, the damage has been done, so to speak. Buckhalter, although there's been representations that they could somehow be screened out or stop working on these issues, they filed a motion, they filed a 19-page brief, and they've already taken these positions against its client's interests, and that's something we can't undo. There can't be a retroactive screening, so to speak, of what's transpired. So it really is our position that this needs to be addressed for this entire process to move forward. I know there's been representation where the cooperation agreement's different, but the cooperations for purposes of pursuing claims, and these Ponzi findings are apparently a big part of pursuing those claims. So, again, we really need to understand what Buckhalter's position is, and we just don't have that information to date. I did talk with my office partner, I talked with committee counsel this morning, and we had discussed these same points. And I made it clear we just need to understand what their position is on this, but we agreed that the hearing should go forward for the 27th. To the extent some type of an agreement, can be reached, we can discuss it at that point in time. But again, this may need to be evidentiary because I'm not quite sure what Buckhalter plans to do or what their involvement may still be, and what role they're anticipating playing at this point in time. We just don't know. So I do think we need to reserve those issues, but would be appropriate to keep on for next week at this point in time.
Thank you, Mr. Ayers. And I know it's hard, particularly for your clients, since they're the ones directly affected by the conflict issue. But if we just table the conflict issue, say there's some totally unrelated law firm involved here, I mean, your UMQA doesn't have a substantive problem with the cooperation. I mean, candidly, I'm not 100% sure I even need to approve this, but the parties are agreeing to cooperate, coordinate efforts, reduce duplication of costs, use a common vendor, right? I mean, all of that seems like perfectly sensible. I mean, it's kind of like that common interest agreement, and the issue's not with the substance of that. It's just with the involvement of the Buckhalter firm, and maybe the way we get this sorted out is there's a broad paragraph just reserving everyone's rights as it relates to that issue. But do UMQA have a broader non-conflict related substantive issue with the cooperation agreement?
No, I think that's right, Your Honor. I don't know how to address it, though. I don't know that we can just add a paragraph, but that's for us to discuss and determine. But otherwise, it's really this conflict issue that came to light and was highlighted, and really wasn't known directly until that cooperation agreement was filed. So I think that's accurate, Your Honor.
Okay. Thank you, Mr. Ayers. Mr. Dyer, any thoughts from you just on this? We're going bite by bite today, so just on this side.
Yes, Your Honor. I think the court has identified the issues that need to be covered, and I would suspect that debtors' counsel will be providing that soon, probably on the reply date. But I also I think that I read the cooperation agreement as the court did. Basically, it's a sort of a joint litigation agreement, and I think absent the conflict issue and absent dropping them out of the strategy piece, which I think also is in UMQA's objection, is that essentially the Buckhalter has to be out of it on those issues. And I don't know if that will satisfy them because as Mr. Ayers has identified, there may be more that we do not know because we haven't seen the full disclosures. So those are my comments on this particular chunk, Your Honor. Thank you.
Thank you, Mr. Dyer. Mr. Kornfeld, or anyone else on behalf of the committee.
Thank you, Your Honor. Appreciate the chance to say a few things. I think the court has looked at and analyzed this the way that the committee counsel did, which is there's a conflict issue that clearly visits UMQA and Buckhalter's relationship. I don't think it visits the substance of the agreement as different people have shown this hearing. I do note that it's not in the cooperation agreement, but there was a 2004 order issued by the court earlier in the case, and the committee counsel, Mr. Bender's firm in particular, has handled that matter from start to finish, including receipt of documents from Umpqua's counsel. And so I note that historically, just for the record today, that there has been an effort to have the committee counsel handle Umpqua matters that might be directly conflicting. The only thing I would add is, as Mr. Ayers said, Mr. Bennett and I did speak with Ms. Schlenker and Mr. Ayers this morning, and we will make an effort to help facilitate an agreed order if we can. Otherwise, appreciate keeping this matter on for next Wednesday, and telephone hearing is perfectly acceptable to us.
Okay. Thank you, Mr. Kornfeld. Okay, well, we'll definitely leave this on calendar for the 27th. We'll circle back at the end about whether we're doing anything else on the 27th. If not, I think we can do that piece by phone, recognizing that perhaps there's some evidentiary component that we need to deal with separately. And again, there may be parts of this that are not today issues, and I assume everyone in Buckhalter's devoting appropriate attention to making sure that at least the Rule 2014 disclosures get appropriately supplemented. Okay, so on the DIP and the Ponzi issues, I have several thoughts. Why don't I go through 3 points, and then I'll hear from Mr. Guruli. First, I've read the papers. I'm not convinced that an adversary proceeding is necessary to address this issue. I fully recognize that if in an actual avoidance action, an adversary proceeding is required. But in various contexts, things come up in bankruptcy cases that are resolved by motion or contested matter in the main case, and the fact that they may have some knock-on consequences for subsequent avoidance litigation doesn't mean that they themselves need to be addressed in an adversary proceeding. And just some examples I'll click through. I mean, substantive consolidation, particularly substantive consolidation for litigation purposes, as the Ninth Circuit endorsed in Bond's opinion, can and often is pursued by motion or pursuant to a plan in the main case. If substantive consolidation occurs, that can have dramatic impacts on preference claims, fraudulent transfer claims. If everyone could just mute their line when they're not speaking, somebody's got like some kitchen equipment or something banging in the background. So substantive consolidation can properly be raised by motion or by plan. That can have dramatic impacts on preference and fraudulent transfer claims, including changing the relevant petition date, changing the solvency analysis, changing what 502H claims exist. Assumption or rejection of a contract can have dramatic consequences on avoidance litigation. Generally, when a contract's assumed, most courts, and I had a long footnote in an opinion I wrote about this in the Astoria Health case, most courts say the preference claims go away upon assumption. Some courts hold that fraudulent transfer claims also go away upon assumption of a contract. In Astoria, I said I'm not sure that's right, that the fraudulent transfer claims go away, but assumption or rejection is something that happens in the main case that may have collateral consequences on later litigation. 363 sales very often have collateral consequences on later litigation. It's not uncommon for avoidance actions to be sold or transferred pursuant to a 363 sale. Sometimes the buyer wants to, quote-unquote, buy and bury the claims, right? So you're buying the operating business and you want to eliminate the preference claims, so you purchase them and then never pursue them. Other times the buyer wants to specifically purchase the avoidance actions to pursue them. The resolution of the 363 motion in the main case may have later consequences on avoidance actions, but that doesn't mean those later consequences necessitate an adversary proceeding. The issue of whether a particular transaction is a true sale or a secured loan. I wrote a long opinion about this in one of my Montana cases involving so-called merchant cash advance financing. The issue could come up in the main case. Very early on, there could be a cash collateral dispute where the debtor says the receivables are our cash collateral. The putative purchaser says, no, that's our property. We bought it in a true sale. the bankruptcy judge may be called upon to determine, in the context of the cash collateral dispute in the main case, whether the transaction was a true sale or a loan, whether the money is cash collateral or not. That could have implications in many different respects for the lender later on in subsequent adversary litigation. I concluded in my Montana case that the transaction was a loan and Montana usury applied, and that was quite punitive for the lender. But if the issue came up in the main case, it could be properly litigated and decided in the main case, even if it has consequences in adversary litigation. Exactly the same analysis would apply with respect to whether a lender is over or undersecured. Cash collateral or DIP financing, debtor takes the position, lender's oversecured, lender says, no, I'm undersecured, therefore I'm not adequately protected. If the court says you're undersecured, that might expose the lender to a preference claim that they wouldn't have if they were an oversecured lender. Issue arises in the context of contested matter, its resolution may have knock-on effects later on. Solvency issues can come up in the main case. The FTX bankruptcy case right now, the cryptocurrency case, has a plan with a settlement matrix that makes very specific and is keyed directly to issues involving solvency. Yet another example, in the context of plan confirmation, the court has to undertake the best interest analysis under Bankruptcy Code Section 1129A7 about what people would get in a hypothetical Chapter 7 and whether the plan's giving creditors at least that much or more so as to satisfy the best interest test. That could affect subsequent preference analysis because the preference analysis also asks what people would be getting in a hypothetical Chapter 7 case. And I think if the judge decided it one way under 1129A7, that likely would hold in the later avoidance action. That doesn't mean, and no court has ever held or would hold, best interest analysis under Section 1129A7 requires an adversary proceeding. Another example, and I'll talk a little bit more about this example in a bit because I dealt with this exact same thing in practice, is you could have a scenario in which the debtor seeks to compromise a contested claim and the debtor is hoping to then put the liability over on an insurance company. So when I was in practice, we represented a debtor that had very long-standing regulatory issues with the Martha Healy, who was then the Attorney General for the state of Massachusetts. She's now the governor of Massachusetts. We settled that claim. The debtor wanted to take the position that there'd be insurance coverage. So insurance counsel included discussion of the reasonableness of the settlement from an insurance perspective on the 9019 motion, and we served it on the insurer. I'll circle back to the specific example. There, the determination of whether the settlement was reasonable, fair and equitable and reasonable within the 9019 ambit, which is something that plainly can be raised in the contested matter, may have had implications for subsequent insurance litigation between the debtor and the insurer in terms of whether it was a reasonable settlement so as to trigger coverage under the policy. That in no way means that the 9019 motion necessitates an adversary proceeding. So here, a determination, the disputed factual issue of whether there's a Ponzi scheme or not is similar in my mind to, is it a loan or is it a true sale? Is it a reasonable settlement where I don't think Rule 7001 requires an adversary proceeding for that discrete question, so I'm not convinced it's necessary that we have to have an adversary proceeding here. So to the extent the various papers are arguing that an adversary proceeding is required, I just don't think that's correct. That again doesn't mean I'm fully bought into what the debtors are proposing here, but I've just seen many examples where something's decided in the context of a contested matter in the main bankruptcy case that may later on have some relevance to subsequent adversary litigation, and that later relevance does not require that there be an adversary. So the first point I wanted to cover on that. The second point, I guess, and I've thought quite a lot about this, and the papers raised this, is this issue about, well, notice issues, who's going to be bound, what's the preclusive effect of determining the Ponzi issue in the main case. Umpqua argues it should get an express carve-out. I think all of the objection parties say it's just unclear what this is going to do. I hinted at this at the last hearing and after having thought about it some more, I'm convinced it would be inappropriate for the court, if we're doing this in the main case, to say anything at all about what the preclusive effect of a Ponzi finding would be down the road. At the last hearing, I used the example of litigation 1 and litigation 2. Normally, litigation 1 just happens. The consequences of litigation 1 are whatever they are. That's decided in the context of litigation number 2. So circling back to the insurance coverage example, in that case, when I was in practice, we served the insurance company with the 9019 motion. The insurance company showed up in the bankruptcy court and said, we're not a party to the case, kind of echoing Umpqua's argument. We don't know why this was sent to us. We think we know what the debtor's up to, and you, bankruptcy judge, are not the appropriate judge to be weighing in on whether there's insurance coverage or not. There are Article 3 issues, Stern issues, jurisdictional issues, and that's not before the court. So we, the insurance company, object to the extent that's what the debtor's up to. The bankruptcy judge in that case, she was a very experienced and wise judge, I think, said, look, I'm not deciding anything relating to that. All I have before me is the 9019 motion. I'm either granting it or I'm not. If I'm granting it and finding that for Rule 9019 purposes, this is a reasonable settlement, maybe that has some effect down the road. Maybe it doesn't. I don't know, and I'm not deciding that. So I think that's a wise teaching that I'm very much inclined to follow here, in part because of the many uncertainties and issues that are raised by several of the parties, including Umpqua and Chris Christensen and their objections about where and how the subsequent avoidance litigation could unfold. And I thought it was helpful, at least Mr. Christensen's papers cited the LLS America case, which stands for Little Loan Shop, which I think is the most analogous event that probably has happened in the bankruptcy court in this district, certainly that I'm aware of. So Little Loan Shop was another large Ponzi scheme case. It was a business in Spokane that was ultimately fraudulent, failed. There was a Chapter 11 trustee appointed, liquidating plan, litigation trust, lots of adversary proceedings, including net winner Ponzi litigation. What happened there was the district court had the bankruptcy court, Judge Williams at the time, do a report and recommendation on some issues, and then wholesale withdrew the reference of some other adversary proceedings. And I mean, I don't have to decide this today, but I imagine the reasoning was if you have net winners who are no longer creditors of the bankruptcy case, the Supreme Court's decision in Grand Financeria, and now we have Stern, which generally tracks the jury trial analysis in Grand Financeria, means this litigation shouldn't be happening in the bankruptcy court. There's either a jury trial right or an Article 3 right, so the district court has to be the one deciding the litigation. I'm exceptionally reluctant and don't think I could, even if I wanted to, tell any district judge anywhere that they're bound by anything I'm doing here. So I don't think I have the power, and I wouldn't arrogate myself to the position to say, if there's litigation where the reference may need to be withdrawn and it may be decided by the folks upstairs who have lifetime appointment, and through which the bankruptcy court derives all of its power and jurisdiction, they get to decide whether they're bound by anything I do. I certainly don't get to tell them they're bound by what I'm doing here. Similarly, with Umpqua, there was a very, very similar lawsuit in the Woodbridge case I mentioned at the last hearing that I was involved in practice, where a bank, I don't remember the name of the bank, but it was essentially similarly situated to Umpqua, was sued. That litigation was not brought in the bankruptcy court. In fact, it wasn't brought in Delaware. It was brought in a federal district court across the country. So I don't know if and where Umpqua is going to be sued, if at all. We don't need to decide that today. But it very well may not be in the bankruptcy court. So I don't think I get to tell some other judge what effect anything I'm doing has on some other lawsuit they get later on. I think there are constitutional problems with that, due process problems with that, and advisory opinion problems with that. Umpqua, questions whether there's a case for controversy at all, and correctly points out that judges should not be issuing advisory opinions. Yesterday, Justice Gorsuch the Supreme Court issued an opinion authored by Justice Gorsuch, which Justice Gorsuch wrote, quote, federal judges are not counselors or academics. They're not free to take up hypothetical questions that pique a party's curiosity or their own. So I think the whole question about what effect a Ponzi ruling has in the main case, if that's what happens, has in any given litigation down the road is hypothetical. That would be an advisory opinion, and would be me encroaching on potentially another judge, including perhaps an Article III judge's territory, to decide in a particular case what preclusive effect, if any, such a finding should have in the context of that particular litigation involving specific parties. I think even starting down this road is what Justice Gorsuch yesterday described as hypothetical questions that pique a party's curiosity or maybe the court's own curiosity. So given all of that, and kind of reverting back to what's specifically before me, I don't see any scenario in which I will be entering an order containing the paragraph contained in its section 3.1 of the proposed order authorizing debtors to obtain supplemental debtor and possession financing. That paragraph 3.1 is a finding that the estate representative is entitled to the benefit of the Ponzi scheme presumption with respect to any avoidance and recovery action relating to the debtors, including any causes of action asserted under section 544 or 548 and other applicable law. That's an advisory opinion. I don't think I can or should do that. So I then look at the proposed DIP loan, which defines final order in Clause 2. It's finding and determining as a matter of law and fact based on the submission by the debtors and in consideration of an evidentiary record that the debtors' pre-petition operations constitute a Ponzi scheme, and then including without limitation for purposes of bankruptcy code sections 544, 548, 550, and other applicable avoidance and recovery debtor, creditor, and related authorities. I may, and we need to talk about the process, be able to get to constituted a Ponzi scheme, but we can drop a period. I'm not getting to the including without limitation, and I'm not getting to paragraph 3.1. So I guess, Mr. Goulet, if that's just a non-starter, I don't know if you've had a discussion with the DIP lender about whether they will be going forward without paragraph 3.1, because if the DIP lender is not prepared to lend without that paragraph and I'm not prepared to give it, I don't know that we have a lot more to do with this.
For the record, Your Honor, Julian Goulet, Civil Government for the debtors. Thank you, Your Honor, for that background. Very helpful to get your views. Your Honor, the very short answer is that I think that's a discussion we have to have with the DIP lender and their counsel. Sitting here today, I can't tell you that they're committed to funding without sort of the second half of that funding condition. But I do hear what you're saying, Your Honor. I think do you want to talk scheduling?
Well, okay. I understand what you're saying, and I understand, that's a discussion that maybe hasn't happened yet. The third point I wanted to raise on this is it does seem to me like on the DIP front, it may make sense to bifurcate this into stages. So at least Mr. Christensen, I think Redmond funding they had some concerns about the definition of permitted liens and making sure they weren't getting primed. But Christopher Christensen for sure raises, I think, a variety of what I'd call economic business terms relating to the DIP itself, including arguing, not obviously deciding this today, but arguing that the effective interest rate is 40%, which is way too high, and just hiring a contingency lawyer would make more sense. Arguing that the DIP loan is unneeded because the debtors have other cash they can use to fund the case, so there's really no need to push this through now. Arguing that the quote from the papers, that the justification and the cost-benefit analysis provided by the debtors and the committee to support the litigation financing are just generic statements, generic platitudes, and that there's really ill-defined exactly what's being litigated, where, when, how, kind of the who, what, when, where, what are we going to get out of this. Those issues all strike me as kind of predicate issues before we even get to the Ponzi scheme. So, I mean, if the DIP lender were prepared to go forward without that paragraph 3.1 in the order, there's still, I think, business issues that have been raised about whether this is an appropriate financing. And I'll just say, Mr. Dyer may remember, I had another Chapter 11 case. It was an operating business that sold fertilizer throughout the Yakima Valley. It was a kind of mid-sized Chapter 11 case with a real business. During COVID, the debtors filed a motion seeking approval of post-petition financing that was essentially one of those merchant cash advance receivable facilities. And the argument that was, well, this is the only way we can save the business, and no one else is willing to lend to us. This is the best we could find. We sought and talked with other lenders, and this is the best deal we got. Some parties in interest in that case opposed that transaction, and I did not approve it because I concluded that the interest rate was too high and that the debtors were essentially proposing to cannibalize themselves through that financing. And unfortunately, the business shut down and converted to a liquidation, but that's how these things go sometimes. So, I certainly, particularly if a party is contesting the economics and the wisdom of moving forward what's being proposed, I will take that analysis very seriously. And it seems to me that's conceptually distinct from until we clear that hurdle, talking about Ponzi issues is kind of an academic exercise. So I guess my question, Mr. Gooley, is does it make sense that maybe next week, that might be too early if Mr. Christensen wants to take some discovery about these, or anyone else wants to take discovery about the business aspects of the DIF loan itself. But we could do that next week. I'm sure probably no one on the phone is okay with doing the full-throated Ponzi hearing on the 9th. We'll talk about that too. But we could do this step one if bifurcating in this fashion makes sense on the 9th. Again, we're going very quick, so my thoughts are not completely well thought out here, but it does seem to me like there's a threshold issue about the DIP facility that logically would make sense to address first, because again, if I conclude that just the business economics or the overall proposal doesn't make sense, we never need to get to the Ponzi issues, at least through this process. So, Mr. Gooley, why don't I hear your thoughts on that?
Yes, Your Honor. Thank you for that, too, Your Honor. I would say it seems to me that if we're talking DIP terms, DIP economics, it's something that the court would, address sort of in the ordinary course of Chapter 11 practice, fairly regularly. And I think on those issues we have, I know a declaration from Mr. Miller about the financing the terms. Obviously, Your Honor knows, but I would highlight that we have full creditor committee, so the investor committee support for the economics for that DIP financing, and it makes a lot of sense, like we've described, as really seed capital for this litigation. I think that, and plan process, I think that the factual issues in dispute are, like I said, something that the court and parties, and certainly Mr. Lesnick, are, pretty facile with in terms of dealing with them all the time in Chapter 11 practice. And what I would maybe suggest, Your Honor, is that we hold the 27th for that hearing. We try to, quickly delineate what issues, may be subject to discovery, or if it's a sort of a limited deposition type of thing for Mr. Miller on that. And then sort of clear, the debtors will clear that first round hurdle. Obviously, our position would be, with committee support, that this is a business judgment rule standard, and that we laid the evidentiary basis for it. And the parties have had on these issues, but certainly on the gift economics since February 23rd. So there's been ample time to notice, and we have had a lot of balls in the air, Your Honor. But my recollection is that no one has really approached us on gift economics in terms of discovery or anything like that, and that we could therefore hear it on the 27th. Your Honor, one thing I would also note about just scheduling, and if Your Honor is leaning toward sort of sequencing these items, is that I think I just would submit to Your Honor that we sort of be mindful of where that's pushing the ultimate outside date for the financing and other packages and relief here, and not, if we don't have the gift hearing on the 27th, and it's pushed a week, that the estates are not burdened with a delay of, an additional 2 weeks before anyone gets engaged on sort of the Ponzi issues and discovery, which we've submitted a timeline for already. Thank you, Your Honor.
Okay. Thank you, Mr. Cooley. Mr. Lesnick, I think you were the main party objecting to what Mr. Cooley called the dip economics. And I think you raised some good points and are asking completely appropriate questions. So why don't I get your thoughts on, if I were to bifurcate that piece off, what timing might make sense to work through those issues?
Thank you, Your Honor. I agree that these are discrete issues that don't relate to the Ponzi, and it does make sense to separate them procedurally before everybody starts spending a ton of money on the much more complicated Ponzi issues. I guess what I had contemplated was that if the debtors are relying for support of the dip piece of the motion just on the evidence that they submitted, that I'm not sure that we really need any discovery, and then we could just have argument. I'm not sure that we need any examination. I mean, I think it's really just argument. That the argument is that they've not demonstrated, they've not met their burden of demonstrating, the various factors that it makes sense, and that it's all the stuff that we said in our papers. So we could just have a hearing. We could do that next week.
Can I just pause you, Mr. Lesnick? And I guess as people know, I don't like to try and hide the ball on people. If the debtors are resting on the papers, I think I would not approve the proposed financing based on the issues and concerns and arguments you've raised. I think we need to put more meat on the bone here, and I need perhaps if no one was opposing the declaration and the analysis would be sufficient, but I don't know that generics necessarily the right term, but in a different context, in a different case, I talked about how it's important for people to do and show their work, and you put the issue in play, and I need to see more than I have for me to be granting that relief. So, I'm assuming the debtors would want to go forward and make that showing so that we have a further hearing related to that.
Thank you, Your Honor. I appreciate that. I guess in that case, what I would suggest is that the debtors then supplement their papers to address these concerns, after which we would have the opportunity, if appropriate, depending on what they say, to do very quick discovery and then have a hearing.
We could do that, or, you could just take the discovery, right, and ask questions, and then you could have Mr. Miller or someone else testify. I don't like trial by ambush, so if they're going to have Mr. Miller testify to firm this up, I think it's totally fair for you to have a chance to depose him first. But rather than having more papers filed in between, we could just skip to that and then have the evidentiary hearing.
That's fine, Your Honor. We're happy to do it that way, too.
Okay. Do you think there's time? Would you be comfortable going forward with this piece of it next week?
That seems pretty quick. We might need one more week if we're going to do depositions, and there may be documents we want to see before that, but even just to do a deposition between now and next Wednesday, I don't know that my schedule permits that.
Okay. And then you have to get up here, which I know is not the easiest thing to do either. So. Okay.
Correct.
Well, you and Mr. Blue and a lot of people, I think. So. Okay, well, let's bracket that. I do think it, given the concerns that have been raised about the dip economics, the effective interest rate, the business rationale for this, the timing and need for it, I think that's a discrete set of issues that it makes sense to do before we start going through the Ponzi exercise, at least in court. That doesn't mean people can't start discovery about the Ponzi. And I do think, this is something where again, if the debtors are seeking this relief, given the issues that have been raised, I'm going to need a firmer record to grant that motion. So, but we can circle back about the timing. All right, so about the Ponzi, I guess. I was thinking the best way to choose through the different subparts of this. So, as I said, I think this can be done in a contested matter, so I'm not convinced an adversary proceeding is necessary. I'm not going to be granting any relief opining on the preclusive effects of this down the road. At most, I'd be making a finding, and it is what it is, and it means what it means. I guess my hope is that the committee and the debtors have kind of thought this through in light of the various issues that have been raised in the objection, because we'll be devoting resources to this, and it's not 100% clear to me exactly what kind of you're buying with those resources. You're buying something. What it is you'd be buying, assuming I were to make the finding, I don't know exactly. But if this is a road that the debtors and the committee think makes sense to go down at this point in the case and through this process, I'm not convinced it's so fruitless that I should just shut it down entirely. I will note I just have in my own mind some questions about kind of is the juice worth the squeeze here. So I've had some concerns about the schedule, and I assume all of the objecting parties have some concerns about the schedule. I do have some particular concerns about the point that Christopher Christensen raised about the pending criminal investigation. And he cited various authorities that I thought made a lot of sense about many of the problems that happen when civil litigation gets out in front of a criminal investigation. I mean, I don't know where that criminal investigation is going to go, but, there are directions that could go where some of the problems with having a bankruptcy court making a Ponzi scheme finding mid-case, go away. But I very cognizant of kind of the Fifth Amendment concerns that were raised and just the logistical concerns, and this strikes me as a not at all frivolous point for Mr. Christensen to be raising. And I guess let me ask Mr. Dyer. I don't know if this is a Western Washington U.S. Attorney's Office or even who's involved in this, but I don't know if you've heard from any of your colleagues throughout the Department of Justice whether they're going to be participating in the bankruptcy case or weighing in at all about this overlay issue.
I don't know of any criminal investigation team that has ever participated in the bankruptcy case, Your Honor. That's all Article 3 issues, and they certainly don't want to squirrel those things if they're going to indict somebody. All of the activities, as far as I can tell, took place in the Western District of Washington, and that jurisdiction would have whatever authority it has over this company. All of its existence was in Western Washington and in Bellevue, as far as I can tell. So my surmise from my experience in the position I'm in is that this is a Western Washington investigation, and we already know the SEC is involved because of the pleadings that are filed, and That may or may not be hand in glove. It may be two different things. I do not know that. If I did, I couldn't say anyway, but I'm not involved in those sides of the Department of Justice activity related to this case or any particular criminal targets. But all of the activities, Your Honor, are in a different venue that would lead me to say it's Western District.
Right. Okay. Thanks, Mr. Dyer. That makes sense, and I understand. I just wasn't sure if anyone and I'm assuming anyone representing the United States in connection with the criminal matters on the phone today? Okay. I'm also not surprised in Mr. Dyer's comment that they often tend to just ignore the bankruptcy court unless they absolutely have to be involved. Makes sense and is consistent with my experience. Mr. Lesnick, I don't know if you'd like to kind of elaborate on this beyond what's in your papers. I mean, again, I find this dynamic very troubling, and I am concerned about rushing forward in a way that steps on other people's toes or creates problems that are well beyond the ambit of the non-Article III bankruptcy court.
Thank you, Your Honor. We agree with that. We put into our opposition papers a request for a stay. It was not a formal, probably properly noticed motion. So it's something that we are considering, which is bringing a separate motion asking for a stay because we do think it is appropriate. And not only does it affect Mr. Christensen, but to the extent that, one or more key witnesses relating to the Ponzi allegations are unavailable to testify, every potential defendant in a Ponzi recovery action could be prejudiced by that. So we do think it's a legitimate issue. I guess, at this point, my understanding is that the criminal investigation is in its pretty early stages. My understanding, I don't know, but my understanding from what I've heard through the grapevine is that the debtors' counsel probably has a lot more information about this than we do. I don't know if they're able or prepared to disclose anything about that. That might help us with the timing of determining, when we might know more or be in a position to decide when we'll know enough to decide whether a stay is appropriate. But those are my concerns.
Thank you, Mr. Lesnick. Mr. Gurley.
Thank you, Your Honor. For the record, Julian Gurley. Your Honor, on the record, I really am not able to speak to that last point, but I do hear Your Honor's views. I think, Your Honor, candidly, you're giving us a lot to think about, and I think we'll have conversations following today's status conference, obviously, internally with the creditors committee and others on this issue and some of these others. Thank you.
Thank you, Mr. Gurley. And again, to be as candid as I can with the parties and having not had a lot of time to meditate on all these issues, Umpqua Bank cites in its papers various cases standing for the authority that a particular procedural route, this is within the context of adversary proceeding versus contested matter, but I think it applies here, that if the trial judge goes down road one rather than road two, that may not be harmless error if there's a subsequent appeal or maybe a fight about the preclusive effect if the record had been different, would have been different on road two. And given this criminal overlay and what Mr. Lesnick said both this afternoon and in the papers, it seems to me like a very easy argument for someone to make, well, if we had just waited for the criminal process to be done, yes, the record would have been different, right? So therefore, taking route one rather than route two, and it probably won't be me deciding this, right? It'll be one of our district judges or maybe the circuit. It's going to be someone who's not on the phone today, right? But that other judge, other panel could say, we kind of baked it by going down road one in the face of the pending criminal investigation, you immediately kind of bake this reversible error problem into the cake right out of the box, which,
yeah. Your Honor, sorry, Your
I just kind of raised. I don't have an answer to that, and again, haven't spent a ton of time doing my own research beyond what the parties raised. But it seems to me like combining that point from the Umpqua brief with that point from the Mr. Christensen's opposition, I mean, leads to what seems to be a potentially really bad place where I said before, we don't really know what the estate's buying here, right? And I mean, maybe this is a problem that you're not buying very much by going down this road.
Your Honor, thank you for the record, Julian Gurley. I would say, Your Honor, just on that point, part of the way we thought about sort of our Ponzi case in chief in response to Mr. Leisnick's and Mr. Christensen's point on it is that we're not relying on Chris Christensen's testimony or anything like that. Candidly, under the standard for proving up a Ponzi scheme, which we briefed, and the evidentiary record we put in through the declarations, including the Kinrich Declaration, Your Honor, it's sort of much more of a sources and uses and accounting exercise, the nature of what we found in our investigation in the books and records in terms of the flow of funds. So I think to the extent that the court, I absolutely hear you, Your Honor, on being protective of sort of Mr. Christensen's constitutional rights. But that's, Your Honor, respectfully not our case. Our case relies on the investigation we did independent of what Mr. Christensen, may or may not say or may or may not be able to take given other consideration.
I understand that, but I guess I assume what Mr. Leisnick would say is that, well, Mr. Christensen might have things he would like to say about why this wasn't a Ponzi scheme, but he doesn't want to open the door to that while the criminal investigation's ongoing. So therefore, he's fighting with an arm tied behind his back or a gag in his mouth, and that's exactly what the Judge Milton Pollack piece and the other pieces in the cases cited in Mr. Christensen's brief. That's exactly the dynamic we're supposed to avoid.
Your Honor, this is Mr. Kornfeld. Can I make a point or two on behalf of the committee?
Oh, sure, of course, yeah. And this is kind of free-form. I'm not as structured as I might otherwise be this afternoon, but again, I've only had there's a lot of moving pieces. We're in kind of that interesting, and it seems like doing this midstream during the case, I mean, is kind of unprecedented. So we're kind of making it up as we go along. So if I'm not as structured as I ordinarily would be, I apologize for that. But happy to hear from you, Mr. Kornfeld.
No, I don't feel that way at all, Your Honor. There's a lot to digest here for you and for all the parties. I just felt there were a few things that might be relevant to hear from the committee. The first thing I'd like to note is there, at least in Western Washington, are a couple examples of, I'll call them major fraud cases. One of them is a Ponzi called the Meridian fraud case. The other was the Mastro case, which I think is still the largest Chapter 7 in the history of the state. In both those cases, there was the Ponzi in the Meridian Fund case. There was dramatic fraud in the Mastro case. In both cases in which our firm was involved, I would just note that there were criminal investigations that worked in parallel with the bankruptcies. They didn't interrupt the bankruptcies in any major way, and they were allowed to go forward. I don't see in this case, while I respect and value the constitutional rights of anyone in Mr. Christensen's position, I don't think those should interfere nor affect how this court handles the Ponzi request. One note that I made last time at our last hearing was that there is, under the Internal Revenue Code 165, a potential ability for investors, of which we have 1,800 here, to take potential losses if there is a fraud/Ponzi finding by this court. Internal Revenue Code 165 grows out of the Madoff fiasco and is designed for just this purpose. So there is not a group that has been part of this discussion so far but I still view as the real party in this case, which is the 1,800 investors that are out $250 million. And when the case was first filed, if Your Honor remembers, we raised the issue of the effective interest rate of the DIP financing. Your Honor, I think, appropriately approved that, even though none of us liked the interest rate then, none of us like the interest rate now. But what I will note is the necessity for it. And I need to be a little pointed in this. Mr. Christensen ran this company. Mr. Christensen left this set of companies in the position of having zero cash and a fairly lousy real estate portfolio that was highly leveraged. Without the financing that this court approved initially, there would be no bankruptcy case. Without financing now, it would be very difficult. We'll provide evidence, but very difficult for the estate to pursue litigation claims. There are many parties that have objected to this that would benefit and prefer that, quite honestly. The industry would not. Do the investors like a 40% or 30% interest rate? No. Do the investors believe it's important and necessary? Yes. In terms of Mr. Christensen, he has his rights. He can pursue his defense, but that should not slow down this particular court on this particular issue, because a fraud finding, a Ponzi finding, is valuable whether it has pure and unfettered preclusive effect or not. And we would ask the court to balance the monumental rights of the investors here. They're really the reason we're here. The reason all of us are here is because $250 million invested by 1,800 people have been lost. And I do not want, and I don't think it's fair for those interests to be weighed without taking into account the magnitude of that and the complete appropriateness of pursuing these in parallel with Mr. Christensen defending himself in the criminal court. He has the right to show up. He has the right to take the fifth. He has the right to raise his right hand and answer questions. If the Ponzi exists, if the evidence in this company demonstrates a Ponzi, it is beneficial to this estate and these investors for you to make that finding. If you decide it didn't exist, it didn't exist. We have considered all the issues in terms of cost effectiveness. We would prefer it to be less expensive than it is. We would prefer it to be faster than it is. I note that it has been 1 year, March of 23, that iCap let the investors know that it was no longer making payments. It's been an entire year. The bankruptcy has been going on 6 months. For investors and individuals that have lost, in many cases, their life savings, that is a long time. And we would urge the court to keep this process going. I know this is substantive in nature, but there's been quasi-substantive arguments made, and I really want to be sure that the investor's voice is heard at this hearing. Thank you.
Thank you, Mr. Kornfeld. And I absolutely appreciate that. And I saw the emergency motion filed yesterday cited Bowler versus Blue Hills Bank and my East Today Ranch's opinion back. I think that the exigencies in Easter Day apply with equal or greater force here, including because of the fact that we're in a significantly higher interest rate environment now than we were when I wrote that opinion, and certainly in 2021 when that other case began. So I do understand and appreciate all that. So thanks, Mr. Kornfeld. I guess just really we've talked about some things. I've indicated kind of what I'm prepared to do if that's the road the debtors and the committee would like to go down. I think I've indicated some things that I'm not at all prepared to do. I still have some concerns, and I'd like to get some briefing. I don't think Mr. Leslie needs to file a separate motion. I mean, he's effectively requested to stay based on the criminal issues and set forth some authorities on that. I'd like to see some arguments on the other side. I understand the debtors need to have maybe some internal discussions, some just talk with the DIP lender, talk with the committee, and maybe just think about, given all the myriad issues that have been raised, again, is the ultimate juice of this process, is this the best time and the best way to do it? And if you think it is, I mean, subject to the concerns I have, I'm comfortable starting to go down that road. I mean, certainly the issue isn't going to go away, and I think to the extent, for example, the three property entity level lenders want information about how their particular entities and their particular hard money asset-based loans had anything to do with the Ponzi. I think getting that information process going and flowing and getting the data room that was referenced up and going makes sense. I mean, even if we're not doing the big fight, the Ponzi fight immediately, the issue's not going away, and this is going to have to get resolved at some point. I don't see, particularly given the number of investors, the number of potential dependents, the defendants who have already been identified, I don't see a scenario in which we have a global settlement and the need to have this decided one way or the other goes away. So, and there's no reason for anyone to wait requesting and receiving documents or information related to that. So, but I guess, how do you think it makes sense to proceed just going step by step in the next week between today and the hearing next Wednesday?
Your Honor, for the record, Julian Gruley, I think adopting Your Honor's sequencing, it makes sense for us to know when we're going to be able to be heard on what I've called sort of the dip economics question. Agreed that does seem like a gating item at this point. So are you thinking, Your Honor, that do you have availability the week after the 27th, Your Honor, if I pull up the calendar for that?
Just one second. Sorry, I just need to pull up a couple of things. Yes, I could do either the 2nd or the 4th of that week.
Thank you, Your Honor. And, Your Honor, sorry, the following week, too, just because I might have written issues in terms of scheduling for that first week in April.
We could do the 8th, 9th, the 10th. I have other matters on the 10th. The 11th, I have a doctor's appointment in the morning that I can move, and then I'm out that Friday for a CLE conference. So really the 8th or the 9th the following week would be the best day.
Okay. Your Honor, what might make sense, because this is a fair amount to digest, and I candidly will need some client guidance in light of the court's comments. Your Honor, could we hold the 27th, at least, Your Honor, I submitted at least a status conference. I can speak to my clients, speak with the committee, and speak to Mr. Lesnick also, and anyone else who is on that sort of first issue of DIP economics, and we could meet and confer and try to determine if we do have any discovery, if they do need deposition, and if we're going to need live testimony, which I know Your Honor prefers in person or not, and just sort of pick it up there and come back to you either through chambers with like an agreed upon suggested schedule, or we could pick it up on the 27th in terms of the status conference, Your Honor. Maybe that's my thought.
I just want to hear from the other parties, but that makes sense to me. I'd add, I think it makes sense to have it at least an initial hearing, and maybe it'll be the final hearing on the cooperation agreement. Again, that by its terms is not conditioned on the Ponzi findings or the DIP litigation financing. I think just based on my review, and I don't think anyone's objecting to the substance, that having the committee and the debtors cooperate as they've agreed is a sensible and efficient way to proceed. We need to get this Buckhalter issue worked out. I think there's a reasonable prospect that can be worked out in the next week. So why don't we just why don't we do this? Why don't we have March 27th? I'll convert that to just phone only. We will have a status conference relating to the DIP financing and the Ponzi issues, and then we'll call it an initial and it may be the final hearing relating to the cooperation agreement, and that's really the Buckhalter conflict issue. If counsel for Umpqua and the debtors can either work something out, or if the debtors want to argue, I can resolve this without the need for any evidence. We can do that without anyone needing to come in person. So that will be telephonic, and then I think discussing then, or if the parties agree, when to have an in-person hearing on the first step, the economic step of the DIP facility makes sense. I know obviously this is deeply inconsistent with the schedule requested in the emergency motion, but I think you'd have almost everyone else on the phone unanimously expressing very significant concerns about that. So does that sound good, Mr. Brewer?
Yes, Your Honor. Thank you.
Okay. And Mr. Lesnick, does that work okay for you?
Yes, I think that makes a lot of sense, Your Honor. We're fine with that consensus.
Okay. And Mr. Ayers, does that work? You're also on as it relates to the cooperation agreement?
Yes, Your Honor, that works just fine.
Okay. I guess I know there are others on the phone, and I don't want to cut anyone off. I think we're largely tabling for the moment the exact process as it relates to Phase 2 and the Ponzi, and I appreciate that the parties need to have some discussions offline and think about this a little more. But why don't I just go through in case anyone would like to say anything today, and if there's nothing to say, that's totally fine. Mr. Ledgerwood or Mr. New? Maybe they drop it. Mr. Ledgerwood? Or Mr. New? Okay.
I'm sorry. I was on mute. My apologies, Your Honor. No, Your Honor. No further comments. Obviously, our client's concern was primarily with the procedures surrounding the Ponzi and the timing of the Ponzi finding. I think those are largely, issues that will be taken up, I guess, next week.
Okay. Thank you, Mr. New. Mr. Baker?
Nothing for me, Your Honor. Thanks.
Okay. Very good. Thank you. Mr. Pratley?
Darren Kratt, Your Honor. Nothing additional for me.
Okay. Thank you. Mr. Free?
Nothing to add, Your Honor. Thank you.
Okay. Mr. Dyer, anything further on your end that you wanted to hit on or cover today?
Your Honor, with your point 2 under the thoughts about the Ponzi preclusiveness, I think the only other point I wanted was to note that the motion filed last night at 10:51 indicated that these parties that who had objected were targets, and that implies, if not, kind of makes it clear that other targets are known, but they haven't been identified. And I think that if we go forward on the Ponzi piece, I think there's some due process thoughts that ought to be made about making sure that those targets know this is happening, except for what the court has said related to exclusive effect and effects. Going to be where the court goes, then that may not be a further consideration as it relates to further going down anything with the Ponzi piece. So I appreciate those comments, but I think I'll keep that tucked away just to see how this may evolve, given what the parties now have to think and consider among themselves. Thank you.
Thank you, Mr. Dyer. I appreciate that, and it's possible this issue may come up during the hearing about the DIP economics as well. Would not be a completely out of left field question to ask if there's been an evaluation of potential targets, and if so, what that list looks like. I just, again, in the interest of being fully transparent with everyone, I gave some thought about whether the debtors should be filing a list. It brought to mind the cases I remember in practice where some courts require disclosure statements, include a list of all litigation claims, and inevitably at the bottom of the list there's some catch-all language that scoops in the world so that if somebody's not on the list, they can't be relied on. I don't know at this point, for example, if someone has done the work to come up with the net winners list or not. In my experience, even if that list exists, there's some threshold point where someone at some point in the future will need to make a litigation judgment about who's too small to be sued. I could think of many issues that are going to come up in the avoidance litigation here, including, I don't believe there's a Ninth Circuit Court of Appeals decision on the extraterritorial application of the avoidance powers. I know there's a Fourth Circuit Court of Appeals decision in some cases from New York, but I don't know that issue's been taken up, but I could see that issue coming up, which again could feed back into who's ever making the litigation judgment about which net winners may have been net winners but are still not worthwhile litigation targets. So I think it was helpful for the debtors to tell and be transparent with all of the objecting parties that they're potential targets. I assume I have no doubt Mr. Dyer is correct that there are other potential targets who are not objectors who probably were served with the papers and that are known, and maybe this comes up a little more in the context of the hearing on the economics of the DIP facility. But after giving it a little bit of thought, I'm not at this point going to order the debtors to prepare a list or to do anything to specifically identify the entire universe of targets. But thank you for raising that, Mr. Dyer. All right. Anything further anyone would like to comment about the cooperation agreement, the DIP economics, or the Ponzi issues more generally? Okay. Is Bruce Medeiros happen to be on the phone this afternoon? So, Mr. Brewy, if you're someone on the team, and I don't think there's a problem on this front with Buckhalter doing it, United Rentals North America filed a motion for relief and stay. The debtors have opposed that. I'm not sure if we need an evidentiary hearing or just a hearing, but I know Mr. Medeiros had reached out to Chambers to try and schedule that. I'd like him to coordinate with the appropriate folks on the debtor side first, and then if you could just reach out and maybe have some dates that would work for the parties, we will get that scheduled. But.
Yes, thank you, Your Honor. I'll do it.
Okay. Anything further today? All right, so just to sum up, we will convert next week's hearing on the 27th to a phone-only hearing. We will treat that as an initial and perhaps the final hearing relating to the cooperation agreement, and a further status conference in terms of matters relating to the DIP financing motion and the Ponzi issues. Everyone is free and welcome to participate by phone next week. So thank you all. I appreciate your time this afternoon and everyone's efforts on this very interesting case. I hope you all have a nice rest of the day. We're adjourned.
Thank you, Your Honor.